So imagine for a second, you own a piece of land, you've paid the taxes, you've got the fence up, and then you find out that because of a clerical error at the registry, or maybe a really clever fraudster, the official title says your land belongs to someone else.
Right, which is terrifying because under the Torrens system we use, a land title is usually final, period.
Exactly. It's supposed to be the ultimate truth. So, are you just completely out of luck? Today we are diving into an exploration into the source material, specifically looking at a stack of legal sources centered on Presidential Decree Town 1529.
Yeah, we're exploring a specific legal safety net called the Assurance Fund.
Right. Our mission here is to understand how this fund protects you from that absolute harshness of a conclusive land title and why it's actually a lot harder to use than you might think.
I mean, it's a fascinating tension. The law prioritizes a stable system where people can trust the paperwork they see. If everyone questioned every single title, the economy would just grind to a halt.
Yeah, you need to trust the system.
Exactly. But because that stability can occasionally crush an innocent person, the Assurance Fund was created as this financial bridge to compensate people who lose their land through absolutely no fault of their own.
And I was looking through the notes on how this is actually funded, and it's not just taxpayer money sitting there. You're actually paying for this insurance yourself.
Yes, upon the entry of a title, a contribution is paid to the Register of Deeds.
Right. It's 1/4 of 1% of the land's assessed value. So to put that in perspective, if your land is assessed at 1,000,000 pesos, you're tossing 2,500 pesos into this collective safety net.
Which really adds up. And while there is a standing fund of 500,000 pesos mentioned in the statutes, it isn't actually capped there.
Oh, wow. So what happens if it runs out?
If the fund runs dry during a massive fraud case, the National Treasurer is authorized to pull from other available funds to cover the gap. The government essentially backs the integrity of the title with its own wallet.
Okay, but here's where I started getting a bit skeptical while reading the sources. It sounds great, but the rules to actually get a centavo are incredibly strict. You have to prove you were deprived of land without negligence.
That is a massive hurdle.
It is. It's like the law treats your land title like a high security vault. If you left the door unlocked or didn't check your mail, the government isn't going to pay for what gets stolen.
And even if you are totally blameless, you can't just walk up to the Treasury and ask for a check. It's a remedy of last resort.
Meaning you have to.
You have to implead both the person responsible for the fraud and the National Treasurer.
And implead is really just legal speak for sue and bring into the case, right?
Yes, exactly. And the execution of the judgment is directed at the fraudster first. The fund only pays out if the fraudster is insolvent, meaning they are broke, dead without assets, or just completely beyond the reach of the law.
So you really have to try and squeeze blood from a stone first.
Precisely. And the compensation is strictly based on the fair market value of the land at the time of the loss. But there are also massive traps where the fund won't help you at all.
Right, I saw that, like a breach of trust.
Yep. If a relative you trusted with your papers runs off and sells the land, the fund slams the door shut. It doesn't cover express, implied, or constructive trusts.
Wow.
It also won't cover mistakes and resurveys that accidentally result in expanded areas. It's strictly for errors or fraud within the registration process itself.
That makes sense. I also noticed a really tight timeline. Generally, you only have a 6-year window to file an action.
Which is tricky, because in real estate, the law usually relies on constructive notice.
Meaning the idea that the second a document is filed at the registry, the whole world knows about it, even if you're just at home drinking coffee and have no idea you were robbed.
Right. If the clock started ticking the moment the fraud happens, most people would be too late before they even realized their land was gone.
Which brings us to the Stylianopolis precedent.
Yes. This is really the most human part of the entire legal framework.
The Supreme Court realized that original owners are often totally unaware of the unscrupulous machinations of usurpers until much later. They can't expect people to check the registry every single morning.
So they ruled that for the Assurance Fund, the timeline should actually run from actual knowledge of the loss.
It's a rare moment where the system chooses reality over strict procedural rules.
It balances the scales. The fund ensures that the finality of a land title doesn't become an instrument of injustice for the innocent. It's there to catch you if you fall through the cracks of a system that values stability above almost everything else.
Which really makes you think about the value of what you actually own. If the law creates this massive financial fund just to protect the stability of the title to keep the economy moving, does this system actually value the physical land itself or just the paperwork that represents it? Something to mull over next time you look at your deed.
You know, for most of us, owning land is the bedrock of security. It's real, it's tangible, it's yours. But what if it wasn't? What if someone could just snatch it away with a forged signature? It actually happens. So today we're diving deep into a legal safety net that's absolutely crucial, but one you probably never even heard of: the assurance fund.
Okay, just picture this for a second. You've owned your property for years, maybe even decades. You have the title safely tucked away. And then out of nowhere, you find out it was sold to someone else without you even knowing. It's a complete nightmare scenario, right? But it's a very real legal problem. So, what on earth do you do when your unbreakable title breaks?
All right, here's how we're going to break this down. First, we'll tackle that whole idea of an unbreakable title. Then, we'll get into what the assurance fund is and how it's supposed to help. We'll see why it's really a last resort. Then look at a super tricky deadline issue and wrap it all up with how the Supreme Court finally brought some real justice to the system.
So let's start at the beginning. This whole idea of an unbreakable title. To get this, we have to understand the system that most property ownership is based on. It's called the Torrens system, and it comes with a big promise and a hidden danger.
The whole point of this system is to make your certificate of title the absolute final word. That fancy term, indefeasible, basically means it can't be challenged or defeated. It's supposed to be like a rock-solid guarantee, giving everyone the confidence that when you buy property, it's really truly yours.
Right. And here's the massive catch. What if a criminal forges your signature, sells your land to a totally innocent buyer, and that new buyer gets a shiny new title? Well, the system is actually designed to protect that new innocent buyer, to keep the system moving, which means you, the original innocent owner, could be left with nothing.
So if the system itself can lead to such a messed up result, there has to be a fix, right? Well, there is. And that's where the assurance fund comes into play. Honestly, the easiest way to think about it is as a special insurance policy, backed by the state for landowners who get burned by the system itself.
And this is the key. The government itself knew that its property system, as good as it is, could still create innocent victims. So, they created this fund specifically to pay back people who lose their land through no fault of their own, people who were wronged because of how the system operates. And you can see its purpose right here. It's all about fairness. It's there to soften the blow of that indefeasible title rule. It's the system's way of saying, hey, if you did everything right and were still a victim of fraud, we're not going to leave you high and dry.
So where does all this money come from? Well, you might be surprised. It's actually funded by property owners themselves. Every single time a property is registered for the first time, a teeny tiny piece of its value, just 0.25%, goes into this fund. It's like a giant collective insurance pool we all pay into.
Now, just because this fund exists doesn't mean getting money from it is a walk in the park. Oh no, you can't just show up and ask for a check. The law makes it very, very clear that this is a last resort. So, let's look at the hoops you have to jump through.
The whole process is designed to go after the bad guy first. So, step 1, you have to sue the person who actually committed the fraud. The law wants the criminal to pay up. It's only if that person is disappeared or is totally broke and can't pay you back, only then can you turn to the assurance fund as the final backstop.
And the conditions are really strict. To even make a claim, you have to be completely 100% blameless. If you're negligent in any way, say you left your title lying around, you're out of luck. And this is critical, it's only for people who are legally blocked from ever getting their actual land back.
Okay, now we get to what was for a long time the biggest, most unfair problem of all, the deadline. Because of a legal concept called the prescriptive period, victims found themselves in a bizarre and unjust race against a clock they didn't even know was ticking.
This is where the whole thing got crazy. For years, the rules said you had 6 years to file a claim. The problem? That 6-year clock started the second a fraudulent title was registered. The law called this constructive notice, which is a fancy way of saying the law pretended you knew about the fraud, even if you were completely in the dark. So your time to get justice could literally expire while you're at home thinking everything is fine. It was nuts. But thankfully, the Supreme Court finally stepped in and said no way. The clock only starts when you actually find out you've been ripped off.
And the Supreme Court's logic here was just brilliant. They pointed out that this whole constructive notice idea was created to protect the new, innocent buyer, to make their title secure. It was never,
ever intended to be a weapon used against the original innocent owner to cheat them out of compensation. They basically said that using the rule that way would make the entire assurance fund pointless. And that brings us to the grand finale, how the Supreme Court finally slammed this ridiculous loophole shut and brought real justice to innocent victims. This quote from Justice Leonin just says it all, doesn't it? Think about it. An innocent owner is already deprived once when their land is stolen through fraud. To then deprive them a second time by using a legal technicality to block their only path to compensation, well, that's just a profound injustice.
So the court's thinking really came down to a few simple points. The fund was created to help the innocent original owner, period. An owner has every right to trust their own title. Using the old, unfair rule created a situation the law never intended. And at the end of the day, basic justice and fairness demand that the clock can't start ticking until a person actually knows they're a victim. It's just common sense. So, what's the big takeaway from all this? The story of the Assurance Fund is this amazing example of the law correcting itself. It shows that even a system that's built on really rigid rules, for good reason, for predictability, can still find a way to be flexible, to inject fairness, and to make sure its safety nets actually catch the people they were meant to protect. And that really leaves us with a bigger question to chew on, doesn't it? This whole thing is a tug of war between predictable, ironclad rules and messy, real-world fairness. It makes you wonder, where else do we see this tension? And when is it right for the rules to bend to make sure the outcome is just?
We spend a lot of time worrying about the physical security of our homes.
Oh, definitely.
Like we buy deadbolts, we install those smart cameras everywhere. Maybe you've got a dog that barks at literally anything that moves.
Even if it's just a leaf blowing across the driveway.
Exactly. We do all of this, to protect the castle, to feel safe. But there's a piece of paper probably sitting in a drawer or maybe a fireproof box somewhere that actually defines whether that castle is yours or not.
The certificate of title.
Right. And the assumption, the thing we all basically sleep soundly on, is that as long as I have that piece of paper and as long as my name is printed on it, the land is mine. It's an absolute...
I feel like a law of nature, like gravity.
Right, like gravity. But today, we're going to completely shatter that assumption.
You really are.
Because there is a scenario, a very real legal reality in the Philippines where you can hold that title, you could be completely innocent, and the government can still look at you and say, sorry, someone else owns this now.
It is the stuff of nightmares, truly. It's the sharp edge of what we call the Torrens system of land registration.
And that is our mission for this deep dive today. We are looking at the dark side of property ownership, but more importantly, we're looking for the parachute.
The safety net.
Exactly. We're analyzing the assurance fund. And to do this, we've got a really great stack of sources here, specifically a detailed review of the 2022 pre-bar examination pointers regarding property registration and Presidential Decree, or PD, 1529.
Which is the bedrock law for all of this. And we also have a case that is going to be our North Star today.
Oh, the spouses Stylianopoulos case.
Yes, the case of the spouses Stylianopoulos. It sounds like a legal thriller, and honestly, it kind of is. It challenges everything we think we know about fairness, about deadlines, and the responsibility of the state.
So the big question is, if the system fails you, if the indefeasibility of your title turns out to be a lie, or at least an illusion, is there a safety net? Or are you just out on the street?
That is the massive philosophical and practical question we are answering today. Because the law has to balance two things that, honestly, cannot easily coexist.
Which are?
On one hand, you have the absolute certainty that a buyer needs to feel safe purchasing land. On the other hand, you have the justice that an original owner deserves when they are robbed.
Let's start with that tension right there.
Yeah.
Because I think most people don't realize that the land registration system isn't really designed just to protect them personally.
Yeah, but
it's designed to protect the economy.
Precisely. That is the why behind the Torrens system. If we go back in time, under the old Spanish mortgage law or even older common law systems, buying land was incredibly risky.
Right. You had to trace the history back for decades.
You had to play detective. You had to ask, did the grandfather actually sell this in 1920? Was the signature real? Was he coerced? It slowed everything down to a crawl.
It made real estate a massive gamble, and nobody wants to buy a lawsuit.
Exactly. You want to buy a house, not a decade of litigation. So the Torrens system introduced a golden rule. The certificate of title is conclusive evidence of ownership.
Conclusive evidence.
Anyway.
Meaning no arguments.
Right. We call this the mirror principle. When you look at the title, you are looking at a mirror that perfectly reflects the absolute truth of ownership. You do not need to look behind the curtain.
You don't need to investigate the seller's whole family history.
Exactly.
Which is great if I'm a buyer. I see the name Bob on the title. I pay Bob the money. I get the land. Clean and simple.
It creates liquidity. It makes real estate a highly tradable asset. But here is the harshness of the system.
The dark side we mentioned.
Right. What if Bob is a crook?
Let's say Bob forged the title.
Let's say he forged it from the real owner, Alice. If Bob manages to register that fake title, and then he turns around and sells it to you, and you have absolutely no idea it's a scam, you act in completely good faith. The law has to make a choice.
Who gets the land?
Exactly. Who gets the land? You, the innocent buyer. Or Alice, the innocent original owner.
See, my gut says Alice. It was stolen from her. If someone steals my car and sells it to you, I get my car back. The police come and take it from you.
In personal property, yes, that's generally how it works. But in land registration, under the Torrens system, the law says you, the buyer, get to keep it.
Wow. Even though it was stolen first.
Yes. Because if the law gave it back to Alice, then no buyer could ever truly trust a title again.
Oh, I see. You would always be looking over your shoulder.
Right. The whole economy of real estate would collapse because that certainty, that mere principle, would be gone.
So the system protects the buyer.
It protects the innocent purchaser for value, or IPV, that's the legal term, and Alice loses her land permanently.
That is just brutal. I mean, it's essentially state-sanctioned theft in the name of economic stability. It's like the government saying, sorry, Alice, your personal loss is the price we pay for a working housing market.
It is brutal. And the thing is, the drafters of the law, the people who wrote PD 11529, they knew this. They weren't blind to this reality.
They knew they were creating victims.
They knew that for the system to work flawlessly, some innocent people were going to be sacrificed on the altar of public faith in the registry. So they created a counterbalance.
A safety net.
Yes, a financial safety net baked right into the registration system itself. That is the assurance fund.
Okay, so it's basically state insurance.
In a way, yes. It is a remedy provided under Section 95 of PD 1529. It effectively says, if the operation of our system caused you to lose your land, and you cannot get it back because we are protecting the innocent buyer, we will pay you the value of what you lost.
So it's the government saying, look, we created a monster that ate your property, so here's a check.
That is the social contract of the Torrens system. It is a financial substitute for the land itself. If the dirt is gone legally, the fund replaces it with money.
Okay, let's get into the weeds on this value of what you lost thing. Because saying sorry doesn't pay the mortgage or replace a family legacy.
Definitely not.
If I lose a prime piece of commercial real estate in Makati because of some sophisticated forgery ring and the law lets the buyer keep it, what is that check actually going to look like?
The rule is the fair market value of the land at the time of the loss.
At the time of the loss.
Yes.
Okay, that's a really critical distinction we'll need to come back to because land values change wildly over time. But I was looking through the notes on PD 1529 and I saw a number that frankly terrified me.
Let me guess. 500,000 pesos.
Yes. 500,000 pesos in today's market. That is not a house. That's a renovation budget for a nice bathroom.
Maybe a parking spot if you're lucky.
Exactly. If that is the cap, this whole system is a joke. It's honestly insulting.
I'm so glad you brought this up because it is, without a doubt, the single most common misconception about the assurance fund. That 500,000 pesos is not a liability cap.
It's not the maximum payout.
Not at all.
Okay, then what is it? Because it is written right there in the text of the law. Section 97, I think.
Think of it like a petty cash drawer or a float in a cash register at a retail store. The law requires the national treasurer to keep 500,000 pesos in liquid, immediately available cash specifically for this fund.
Oh, I get it. It's the standing fund.
Exactly. It's what is in the wallet ready to go right now.
So it's purely for liquidity purposes.
Right. If you win a judgment for 50 million pesos because you lost a massive estate, the law explicitly authorizes the national treasurer to make up that deficiency from other funds in the treasury.
So they don't have to go back to Congress.
No, they don't need a special act of Congress. They don't need a new appropriation bill, which, as we know, could take years. The law itself acts as the continuous appropriation.
Wow. Okay. That is a huge relief. So the state really does stand behind the full value, regardless of how much is in that specific bucket at that exact moment.
Correct. The state is the ultimate guarantor. The 500,000 is just the operational floor, not the ceiling.
Okay. That makes me feel much better. But Just because the money is there doesn't mean they hand it out easily. I'm guessing you don't just fill out a quick form on a website.
Far from it. Gaining access to the assurance fund is arguably one of the most difficult procedural obstacle courses in all of Philippine law.
I really got that sense from the source material. It looks like they put up every barrier possible to prevent you from actually collecting.
It is designed to be difficult.
It's like a video game where you have to beat 3 incredibly hard bosses before you even see the prize.
That's a great analogy. It's designed to be a remedy of last resort. You cannot just walk up to the counter and say, I was scammed, pay me. You have to prove you have exhausted literally every other option.
So walk me through this obstacle course. Let's stick with our hypothetical victim, Alice.
Okay.
She lost her land to a forger who sold it to an innocent buyer. She wants her money from the government. What does she have to prove?
We have to look at this in 2 stages. The conditions of the victim and the hierarchy of the lawsuit itself. Let's start with the victim, Alice.
Okay, condition number 1.
Condition number 1. You must be deprived of land by the operation of the Torrens system.
Meaning it was the registration process itself that killed her ownership?
Right. If she just lost possession because someone is illegally squatting on the land, that's an ejectment case. You call the police or go to the regular courts.
The assurance fund doesn't care about squatters.
Exactly. This is about the title itself. And attached to that is the absolute requirement that she is barred from recovering the land.
Meaning the land is gone for good.
Right. If the land is still in the hands of the forger, you don't sue the fund.
You sue the forger to get the land back.
Yes, you sue to cancel the fake title and get the dirt back. The fund is only a substitute when the land is irretrievable, which usually means it's now with that innocent purchaser we talked about. The law always prefers to give you the land back if legally possible.
That makes perfect sense. If you can fix the problem, fix it. If you can't, then you look for compensation.
Now, condition number 2 is the killer. No negligence. The claimant must be entirely free of negligence.
Entirely free. That is a very strong word. It sounds extremely unforgiving.
It is interpreted very strictly by the courts.
So give me an example. What counts as negligence?
Well, if Alice gave her duplicate title to a friend just for safekeeping, and that friend turned around and committed the fraud, the court might say that was negligence on Alice's part.
Just for trusting a friend.
Yes. Or if Alice signed a deed of sale without reading the fine print, thinking it was a mortgage. Negligence. If Alice waited 20 years to check on her vacant property while squatters build a whole commercial complex on it, that's laches or negligence.
So if you crack the door open even a tiny inch for the fraudster, the state just slams the door right on your fingers.
Precisely. The assurance fund is reserved for the purely innocent, the person who did absolutely everything right, kept their title in a safe, paid their real estate taxes every year, didn't trust the wrong people, and still got robbed purely by the invisible machinery of the registration system.
Okay, so let's assume Alice is a saint. She's perfect.
Yeah.
0 negligence. She qualifies. Now, who does she actually sue? Does she just sue the government?
This is where we hit the procedural trap. You cannot sue the assurance fund alone.
Why not? They hold the money.
Because of that last resort principle,
Yep.
you have to file a multi-party suit. You must drag 3 separate entities into court.
3.
Yes. Number 1, the person who actually caused the fraud, the forger or the thief. Number 2, the Register of Deeds, usually just as a formality to bind the official records. And number 3, the National Treasurer who holds the purse strings.
It's a group project where everyone in the group hates each other.
Exactly. And here's the last resort doctrine in full action. Even if Alice wins the case,
Right.
and the judge slams the gavel and says, yes, Alice, you are owed 10 million pesos, she still cannot go to the treasurer to collect.
Wait, why not? She won the case. The judge said pay her.
Because the sheriff must first try to execute the judgment against the private individual, the fraudster.
Oh, so she has to squeeze the thief first.
Yes. The sheriff has to check the fraudster's bank accounts, seize his car, trying to sell his personal assets to come up with the 10 million.
But criminals usually don't keep the money. They spend it, they hide it in crypto, or they gamble it away.
Correct. They are rarely sitting on a pile of cash, but the law strictly requires you to try. Only after the sheriff returns with an official report saying, this guy is completely insolvent, he has nothing, he is broke, only then can you turn to the national treasurer and say, okay, now you have to pay.
So the government is basically a co-signer on a loan.
Yes.
They only pay if the principal borrower totally defaults.
That is the perfect analogy. The taxpayers are the ultimate backup. And there's a very interesting legal mechanism here called subrogation.
Subrogation, what does that mean in this context?
Once the government finally pays Alice that 10 million pesos, the government steps into Alice's shoes.
Right.
The state now has the right to hunt down the fraudster for the rest of his natural life to get that money back.
Ah, I see. Well, good luck to them. I feel like the national government might have better tools to find hidden money than Alice does anyway.
Usually, yes.
Now, there was a specific kind of morbid edge case in the review notes that caught my eye.
Let me guess. The dead fraudster.
Yes. What if the fraudster is dead? Because these legal cases, they don't happen overnight.
They drag on for a decade or more. It happens all the time. By the time you discover the fraud, investigate, file the suit, and get a judgment, the original forger might be 6 feet under.
So in that scenario,
Yeah.
do I have to sue his estate? Do I have to go after his kid's inheritance to get my money back? Because that sounds like a whole other nested legal nightmare.
Generally, in civil law, yes, you would sue the estate. But PD 11529 offers a rare moment of mercy right here.
Oh, nice.
If the person responsible for the fraud is dead, and it appears they left no property, meaning there is no real estate to sue, the law allows you to skip that step entirely.
You just get a pass.
You get a pass. You don't have to go through the expensive charade of suing a ghost with an empty wallet. You can proceed directly against the assurance fund.
Well, that's pragmatic. At least there is one shortcut built into this maze.
One shortcut, yes. But that brings us to the biggest, tallest wall of all. The one that almost completely destroyed the spouse's Stylianopolis. Time.
Ah, the ticking clock. Prescription periods.
Every legal right in our system has a lifespan. If you don't enforce it within a certain defined period, it simply dies. For the assurance fund, the general rule is 6 years.
6 years? I mean, on the surface, that seems like a decent amount of time, assuming, of course, that you know you've been wrong.
Exactly, but if you don't know...
Right, if you don't know, 6 years passes in the blink of an eye. And that is why the case of Stylianopolis versus Register of Deeds is such a massive landmark case, right?
It absolutely is. It exposes the fundamental flaw in how the timeline is calculated.
Let's really set the stage for this case. Who were the Stylianopolis family?
They were the legally registered owners of a lot in Legazpi City, but crucially for this story, they were living in Spain.
Okay, so they were effectively absentee owners. They didn't have a caretaker or an administrator checking on the lot every single day.
Right. Which, to be fair, is not a crime.
Of course not. You're allowed to own land and live somewhere else. Honestly, having a piece of land waiting for you while you live abroad is kind of the dream.
Absolutely. And they had the most important thing. They had their owner's duplicate certificate of title safely in their possession in Spain. They felt completely safe. They slept well at night.
The golden ticket.
Right. But back in Legazpi City, a nightmare was unfolding without them knowing. A usurper, someone pretending to be the owner, managed to sell their land.
Do we know how?
We don't have the full granular details on the mechanics of the forgery in the case summary, whether it was a fake ID, a completely fabricated deed of sale, or maybe an insider, but somehow they successfully bypassed the registry's checks. The title was officially transferred. And eventually, the land was sold again to an innocent purchaser for value.
So the Stylianopolis family is sitting there, sipping wine in Spain, holding their title document, thinking they own a beautiful lot in Legazpi. Meanwhile, a total stranger's probably building a house on it, holding a brand new title that says he owns it.
Exactly. And when the spouses finally found out years later, they launched a massive legal battle. They sued to get the land back.
Which is condition number 1.
Right. And they lost that fight because the court ruled the current buyer was an innocent purchaser. The mirror principle protected the new buyer.
So they pivoted.
They said, okay, assurance fund, we lost the land to the system. Pay us the value.
And the government basically said, check your watch.
The government argued they were completely time barred. They pointed to the legal concept of constructive notice.
I really hate this concept. But we have to explain it because it is the primary villain in this story. What exactly is constructive notice?
It is a legal fiction. Section 52 of PD 129 explicitly says that the act of registration is notice to the whole world.
Notice to the whole world. That is incredibly dramatic language for filing a piece of paper in a cabinet in a provincial city hall.
It means that the exact moment a document is entered into the official records of the Register of Deeds, the law presumes that everyone, you, me, the spouses sitting in Spain, knows about it.
Even if I'm in a coma. Even if I'm literally an astronaut on the International Space Station.
It is absolutely refutable. You cannot go to court and say, Your Honor, I didn't know. The law says you should have known because it was a matter of public record.
So the government's argument against the spouses was, hey, this fraud happened, say, back in 1995. We registered it. The clock started ticking right then. You showed up 10 years later.
Right.
Dad, so sad.
Exactly. They were effectively arguing that the spouses Stylianopoulos should have been calling or visiting the registry of deeds in Legazpi City every single week, just in case someone was secretly stealing their land.
Which is just absurd. If I have my original title in my safe, why on earth would I check the registry? The whole point of having the title is that I don't have to check. The system is supposed to be indefeasible.
That is the core conflict of the case. The government used a rule that was meant to ensure stability constructive notice to deny justice to the actual victim. It went all the way to the Supreme Court.
As it should have.
And the court had to decide. Does this notice to the whole world rule apply to prescription periods for the assurance fund?
I feel like if the court said yes, the assurance fund would become completely useless overnight. Because by the time you realize you've been scammed, the 6 years would almost always be up. Fraudsters don't usually call you up to let you know they're stealing your land. They do it quietly.
You hit the nail right on the head, and that is exactly what the Supreme Court realized. They ruled that constructive notice does not apply to actions against the assurance fund.
Thank goodness. Some common sense finally prevails.
They looked deeply at the purpose of the rule. Why do we even have constructive notice? We have it to protect the buyer. It allows a buyer to rely on the public record without fear. It's a shield for the innocent purchaser.
But the government was trying to use it as a sword against the original owner.
Correct. The court basically said you cannot use a rule designed to uphold the Torrens system to defeat the very remedy designed to cure the system's inevitable failures. The court explicitly called it an absurdity.
I love when the Supreme Court uses the word absurdity. It's just polite, highly educated legal speak for this is incredibly stupid.
It really is. They emphasize that the spouses were not negligent in any way. They relied on the indefeasibility of their own title. They had absolutely no reason to suspect fraud.
Right.
To penalize them for not discovering a secret, highly concealed crime would completely defeat the laudable purpose of the assurance fund.
So if the clock doesn't start when the fraud is registered, when does it actually start?
The main ruling suggests it starts upon actual discovery of the fraud, when you, as a human being, actually find out.
Okay, that's fair.
But this is where the deep dive gets really, really interesting, because the concurring opinions, specifically from Justice Leonin and Justice Kaguya, went even deeper into the philosophy of what a loss actually is.
I read these opinions in the notes, and these are where the justices really flex their intellectual muscles. Justice Leonin had this concept he called double deprivation. It sounds incredibly intense.
It's a very human rights-centric view of property ownership. Leonin argued that the original owner is actually victimized twice. First, by the fraudster who steals their identity and forged the document. That's a private crime.
Right, bad guy does bad thing.
But the second deprivation is committed by the state itself.
By the state?
How?
Yes.
Because the state, through the mechanical operation of the Torrens system, validates that fraud. By issuing a clean new title to the innocent buyer and saying, this is valid now, the state effectively finalizes the theft. Justice Leonin argued that because the state is an active participant in this deprivation, it has a much higher duty of care. It cannot just hide behind legal technicalities like constructive notice to avoid paying.
The state cannot participate in the theft and then set a hidden timer on your complaint. That is an incredibly powerful argument.
Exactly. He argued the clock should only start when the innocent buyer registers the title and there's actual knowledge by the victim.
And then there was Justice Kaguya's opinion. He got really technical with the timeline, but in a way that I think actually helps the everyday victim the most out of all these interpretations.
I agree completely. Kaguya focused heavily on the specific definition of the word loss. Remember, the statute says the fund pays for the loss of the land or interest. He asks a simple question. When did the loss actually happen?
Well, the government would say the loss happened when the fraudster sold it to the new guy.
Right. But Kaguya said no, because the spouses actually sued to recover the land first. They fought a multi-year court battle to cancel the fake title. And while that battle was happening, there was a chance, a real theoretical legal possibility that they could win the land back.
Right. You haven't lost the game until the final whistle blows. As long as the case is alive in court, you might get the physical land back.
Precisely. So Justice Kagior argued that the loss didn't become a legal reality until the court judgment became final, declaring that the buyers were indeed innocent purchasers and the Stylianopoulos family could definitely not get the land back.
That changes absolutely everything. That means the 6-year clock for the money doesn't even start ticking until the lawsuit for the land is completely finished.
Correct. And think about why that matters. It saves the victim from having to file 2 totally contradictory lawsuits at the exact same time.
Which would be so awkward. Your Honor, I am suing because I definitely still own this land, but also in this other courtroom, please pay me 10 million pesos because I definitely lost this land.
It would be legally schizophrenic. Kagiyo's view allows the process to unfold logically and chronologically. You fight tooth and nail for the land. If you lose that fight because of the IPV rule, then, and only then, do you fight for the money.
That is a massive procedural win for property owners. It acknowledges the simple reality of how slow the justice system actually is. If you had to sue for the money within 6 years of the fraud happening, but the land recovery case took 10 years to resolve, you would be time-barred from the money before you even officially knew you lost the land.
It does. It turns the assurance fund from a nice theoretical promise into a genuinely reachable reality.
So the spouses Stylianopoulos finally won the right to sue. They cleared all the procedural hurdles. Justice was served, at least in the sense that they could finally get paid what they were owed.
Yes, eventually.
But before we completely wrap this up, we need to look at the fine print. We established earlier that no negligence is a strict requirement. Are there other specific situations where the fund just says, absolutely not?
Yes. Section 101 of PD 1929 gives us the hard exclusions. We mentioned negligence, but there are 2 others that are very specific and very important. First, breach of trust.
Breach of trust. What does that actually look like in the real world?
I call this the treacherous nephew scenario. Let's say you give your nephew a general power of attorney to manage your farm while you're away. You trust him implicitly, but he uses that power to sell the farm to a buyer and then runs off to Macau with all the money.
Okay, so I come back, I lost my land.
Yeah.
The system officially registered the sale because he had a valid power of attorney. Can I claim the assurance fund?
Yeah.
Why not? The result is exactly the same as the forger. I am landless and broke.
The key distinction here is voluntariness. You voluntarily chose your nephew as your agent. You placed your trust in him. The state insures against the system's internal failures and against complete strangers committing fraud. It does not insure against your own bad judgment and character.
Because the state says, hey, we didn't pick your nephew. You did. That's on you.
Exactly. If the breach happens within the circle of trust that you created, whether it's an express trust, implied, or constructive trust, the assurance fund is permanently closed to you. You have to sue your nephew. The state refuses to be the guarantor for bad business relationships or bad family dynamics.
That is brutal, but I guess it's fair. Personal responsibility and all that. What is the second exclusion?
Survey mistakes regarding area. Specifically, if a mistake in a resurvey or subdivision results in an expansion of your land area in the title, and then the government later corrects it and takes that extra land back.
Oh, I see. So if the government surveyor screws up and accidentally types that my 100 square meter lot is actually 1,000 square meters,
Yeah.
and I live like a king for a year thinking I'm suddenly a land baron, and then the registry says, whoops, typo, and changes it back to 100.
You cannot sue the fund for the loss of that 900 square meters.
Yeah, because I never really owned it in the first place.
Exactly. It was a paper windfall. It was an illusion. You cannot claim damages from the state for losing something that was never legally yours to begin with.
Okay, that's just basic logic. You can't profit from a clerical typo.
Correct. The fund is strictly for restitution, not for profit.
Okay, final logistical question for you. We talked extensively about the 500,000 peso float earlier, but where does the actual money come from? Is this taxpayer money? Do I pay for this every time I buy a soda at the convenience store?
That's the brilliant part. It's actually a self-sustaining ecosystem within the registry itself. The funding comes directly from the users of the system.
No fees.
Yes. Every single time a certificate of title is originally entered, a specific fee is collected. The rate is 1/4 of 1% of the assessed value of the land.
1/4 of 1%. That sounds tiny. Like 0.25%.
It is tiny on a per-transaction basis, but think about the sheer volume of real estate transactions happening across the entire Philippines. Every new condo, every subdivision lot, every farm being titled, every single transfer. It aggregates into a massive, massive pool of money.
And what if the land is raw? Like what if there is no assessed value yet because it's never been taxed?
Then the law requires a sworn declaration of value by two completely disinterested persons, subject to court approval. They ensure a fair market value is pegged, just so that 0.25% fee can be properly calculated.
And all this money goes straight to the national treasurer.
Yes, into official custody. And here is where the cap logic we discussed comes full circle. The treasurer invests this money. It doesn't just sit in a vault gathering dust. They invest it in government securities until the principal plus the interest reaches that 500,000 peso standing fund level.
And then what happens to the rest?
Any excess over that 500,000, which given the real estate market is presumably millions or billions by now, is paid into the assurance fund proper and reported annually to the budget secretary. It is a perpetual financial machine. New titles effectively pay for the safety and security of old titles.
You know, it's actually a really elegant system design when you step back and look at it. It taxes the transaction itself to ensure the stability of the whole market.
It is elegant, ideally.
Ideally. Assuming you could actually survive the 10-year obstacle course to get your hands on it.
That is always the caveat with the law. It works, but it requires incredible stamina.
So, bringing this all together, the Torrens system is ultimately a huge trade-off.
Yeah.
We traded the natural, almost primitive right of I own this dirt because it's mine for the commercial necessity of I own this dirt because the paper says so.
And the assurance fund is the steep price the state pays for making that trade-off. It is the formal acknowledgement that in prioritizing the paper over the dirt, innocent people are inevitably going to get hurt. The fund is the state's attempt to make them whole again.
But as we learned so clearly from the Stylianopolis case, the system has a very strong tendency to fight back. It tries to use its own internal rules like constructive notice to block the exit doors.
Which is exactly why that Supreme Court ruling is so absolutely vital for property owners. It stripped away the cold technicality and looked at the actual equity of the situation. It declared that the state cannot create a safety net and then tie it completely shut with bureaucratic red tape. It breathed real life back into the remedy.
It prevents the law from just being a giant game of gotcha. You know, this whole conversation really makes me want to go home, open up my fireproof safe, and just stare at my title for a while. Maybe casually check the registry of deeds tomorrow, just to be absolutely sure my name is still the one printed on it.
Honestly, it's not a bad idea. We like to think of property rights as absolute, unchangeable things like gravity, but they really aren't. They are laws written by men, and laws written by men inevitably have loopholes, systemic failures, and fraudsters looking to exploit them.
Here's a thought to leave you with, listener. Think about the fragility of what you own. You can do everything right. You can be the perfect, law-abiding citizen. You can hold your original title right in your hand. And you can still legally lose your land to a system designed to protect a complete stranger. The assurance fund is literally the only thing standing between you and total financial ruin in that scenario. But as we've seen today, it's not a check they just mail you with an apology. It is a fortress you have to lay siege to. The real question is, if this nightmare happened to you, would you have the financial and emotional stamina to fight for 6, 10, or 15 years to get what is rightfully yours?
And that is exactly why understanding the remedy of last resort is just as important as the first step of buying the land. The system ultimately works for the vigilant.
The system works for the vigilant. I really like that. Thanks for guiding us through this incredibly complex maze today.
Always a pleasure to dive deep into these concepts.
Until next time, listener, keep your title safe.
Welcome to the debate. Today, we are opening the books on a mechanism that arguably holds the entire Torrens system of land registration together. Or, well, depending on your perspective, serves as a calculated illusion. We are analyzing the Assurance Fund under Presidential Decree number 1529.
Yeah, it's a topic that sits right at the intersection of, bureaucratic efficiency and absolute heartbreak. We are talking about the safety net that is supposed to catch you when the state's own machinery fails you.
Right. And to set the stage, we really have to understand the stakes. The central tension we are wrestling with today is this concept of indefeasibility. In the Torrens system, if an innocent purchaser buys land in good faith, their title is rock solid. It doesn't actually matter if the seller obtained it through fraud or a forged deed. Once that title is in the hands of an innocent purchaser for value and IPV, the law protects them absolutely.
Which sounds great for the buyer, but we have to look at the other side of that coin. For the innocent buyer to be secure, the original, completely innocent owner must lose their land. It is a zero-sum game. The system effectively strips ownership from one innocent party just to protect another.
That is the harsh reality. And that is exactly where the assurance fund comes in. The question we are debating is this. Is this fund a robust state insurance policy designed to make that victim whole? I will be arguing that it is not. I'll argue that it is strictly a remedy of last resort, a secondary backstop that is heavily gated by procedural hurdles, specifically the prescriptive period, because its primary purpose is to protect the system's solvency.
And I naturally come at it from a different angle. I will argue that the system's primary goal, when it fails a citizen, must be equity. Procedural technicalities shouldn't bar compensation when the state's own registry facilitates the theft of land.
Okay, let's get straight into the architecture of this fund. To understand my position, you really have to look at the strict letter of the law, specifically Presidential Decree 1529. The Assurance Fund is indeed intended to relieve innocent persons from the harshness of the doctrine that a certificate of title is conclusive. We agree on that benevolent purpose. However, the law frames this very clearly as a remedy of last resort. Look at Section 97. The government is not an insurer in the commercial sense. You don't just file a claim and get a check in the mail. The law explicitly states that the assurance fund is answerable for damages only if the person responsible for the fraud is insolvent. The state acts as a guarantor. It's a backstop. The claimant has a heavy burden here. They must prove they were not negligent, and they must prove they are legally barred from recovering the actual land because it is passed to an IPV.
I hear that, but I hesitate on this whole last resort framing being its defining feature. It feels like a convenient excuse to deny valid claims. Consider the economic reality of what is actually happening. The compensation envisioned by the law is the fair market value of the land at the time of loss. Now, why does the state offer that? Because the Torrens system, purely for the sake of public policy, tilts the scale in favor of the new buyer. If the state decides that the IPV wins just to keep the real estate market stable, then the state owes a debt of justice to the person who lost the land. It isn't a gift, it's a balance sheet correction for a state-sanctioned transfer of wealth. To hide behind procedure is to ignore the substantive injustice the system itself creates.
A debt, perhaps, but one with strict necessary terms. You cannot simply bypass the procedural firewall the law erects just because a situation feels unfair. Let's unpack that procedure, because it's important to understand just how rigorous this is. Under Sections 95 and 96 of PD 1529, there's a very specific sequence of actions required. You cannot just sue the assurance fund on day one. You must file an action against the person responsible for the fraud and the Register of Deeds and the National Treasurer.
Right, all at once.
Yes. And it doesn't stop at filing. You have to get a judgment. Then, once you have that judgment, execution must first be directed at the fraudster's assets. You have to actively try to recover the damages from the person who duped you.
You have to try to wring the money out of the criminal first, which, let's be honest, takes years.
It takes time, yes, but it is necessary. It is only if the sheriff returns the writ unsatisfied, meaning the fraudster is totally insolvent, that the state finally pays. This hierarchy is crucial. It proves the fund is not a primary liability of the state. It safeguards public funds against claims that should be settled between private parties. The state effectively says, we will help you, but only if the actual bad guy cannot.
That is a compelling argument for the general rule, sure. But have you considered the exception explicitly mentioned in our source material? The law actually anticipates a scenario where the person causing the fraud passes away, leaving no property.
Yes, that is a specific edge case, designed for procedural efficiency.
But it is a revealing edge case. If the fraudster dies without assets, the law excuses the claimant from the requirement of impleading them. The state says, okay, in this specific case, you don't have to chase a ghost. This proves that ultimately, the fund is insurance for the victim. When the fraudster cannot pay, whether because they are broke or because they are dead, the state steps in. The procedural hierarchy you are so focused on is really just a filter to save the state money, but the core function remains insurance.
I'm not convinced by that line of reasoning, because even in that dead fraudster scenario, the concept of subrogation still applies. When the government pays out from the assurance fund, Section 97 implies the government is subrogated to the rights of the plaintiff.
Meaning they can go after the fraudster's estate?
Exactly. The state expects to be able to go after other parties or securities to get that money back. The state acts as a financial backstop, essentially fronting the money when the primary liable party fails, but it retains the right to recoup. That is distinct from a pure insurance policy, where you pay a premium and are guaranteed a payout regardless. The state is protecting the registry, not the individual's portfolio.
I think we are splitting hairs on the definition of insurance to justify a system that often pays out absolutely nothing to victims. But let's move to the real killer here. The procedural hurdles are annoying, but the prescriptive period is fatal. This is where your reliance on constructive notice creates a true, measurable injustice.
Constructive notice is not a weapon. It is a shield for market stability. The general rule established by the Supreme Court is that the right of action accrues from the moment the action could be commenced. In the context of land registration, the rule is absolute. Registration constitutes constructive notice to the whole world.
There is that phrase again. Notice to the whole world.
It is the bedrock of the Torrens system. When an instrument is registered in the Office of the Register of Deeds, everyone is presumed by law to know about it. Therefore, the legal discovery of the fraud is deemed to have taken place at the exact time of registration. If you wait more than 6 years from that date to sue the assurance fund, you are time barred. It creates certainty. We cannot have liability hanging over the system for decades just because someone didn't check the registry.
But applying that rule to the assurance fund defeats the fund's laudable purpose entirely. I'm looking at the Spouses Stylianopoulos versus Register of Deeds case. This case is tragic, and it's highly illustrative of the flaw in your argument. The court, or at least the dissenting and concurring opinions, recognized that constructive notice is designed to protect the innocent purchaser. It is meant to tell the world, hey, this person owns this land now, so don't try to buy it from anyone else.
Correct. It warns off competing claims.
Yes, but you are using it to trap the victim. As the source material points out, registration of the innocent purchaser's title should be a condition sine qua non, a necessary condition to file the suit. You obviously can't sue the fund until the land is legally gone, but it should absolutely not be the starting gun for the deadline. If you apply constructive notice here, you are depriving the victim twice. First, they lose the land of the fraud. Second, they lose their compensation because of a legal fiction that says they should have known about a forged transaction they had no part in.
I get that it sounds harsh. It is an emotional argument. But legal certainty requires a fixed point in time. If we don't use the registration date, when does the clock start? That becomes entirely subjective. You'd have a claimant showing up 20 years later saying, oh, I just found out today.
It isn't subjective. It's a matter of when the loss actually crystallizes. Let's look at the Stylianopoulos case in detail because it highlights exactly why your fixed point in time is so flawed.
Go ahead.
The spouses Stylianopoulos were residents of Spain. They owned a lot in Legazpi City here in the Philippines. They had the original transfer certificate of title safely in their possession. They did not have an administrator in the Philippines, and why would they? They had the title. They relied on the Torrens system's specific promise that their title was indefeasible.
And in the meantime?
In the meantime, a fraudster poses as the owner, sells the land to a buyer, and that buyer registers the sale. Under your strict rule, the clock starts ticking right then. The owners are in Spain, sleeping soundly. 6 years pass. They finally come to the Philippines, check the land, and realize it's gone. They sue, but the court says, sorry, you are time barred. You legally knew about the fraud 6 years ago when it was registered.
It is a harsh outcome. I fully admit that. But consider the alternative. This brings us to a fascinating divergence in jurisprudence, specifically between Justice Leonin and Justice Kagiwa in that very case. And I think Justice Kagiwa offered a very nuanced, technically sound view on when the loss actually occurs. He argued that the original owners didn't legally lose their land just because a fraudster registered a fake deed.
Right, because a forged deed is technically void.
Precisely. In the strict eyes of the law, that forged deed conveys nothing. The original owner still owns the land. The loss only becomes real in a legal sense when a court declares that the person currently holding the title is an innocent purchaser for value. Until a court actually says, sorry, this buyer acted in good faith, so they keep the land, The original owner still has a fighting chance to recover the property through reconveyance.
So Kaigua is saying the prescriptive period shouldn't start until the court judgment?
Exactly. He argues the 6-year period should count from the notice of finality of the court judgment determining the buyer is an IPV. That is when the doors to land recovery slam shut and the door to the assurance fund finally opens. It's a precise, procedural trigger that doesn't rely on the vagueness of actual knowledge. It keeps the system objective.
Well, it is precise, I'll give you that. It's definitely better than the registration rule, but I just don't buy that it's the most just approach. It assumes the victim knows they need to go to court in the first place to get that judgment. I find myself aligning much more with Justice Leonin's view. He argues that justice and equity demand the period starts upon actual knowledge of the original holder.
But actual knowledge is incredibly difficult to prove. It incentivizes ignorance. It encourages owners to just sit back and never check on their investments.
Look at the reality of the Stylianopolis case again. They were in Spain. They had absolutely no reason to check the registry in Legazpi City. To demand that they should have known, or even that they should have waited for a court judgment they didn't know was happening, is absurd. The system simply cannot demand omniscience from property owners.
It's not demanding omniscience. It's demanding basic diligence. If you own property, you have a responsibility to oversee it. If you abandon it for decades while living in spleen, you are frankly inviting trouble. Justice Leonin's approach creates a massive sleeper liability. If actual knowledge is the standard, a claim could theoretically be filed 50 years later because the owner just found out. That destroys the actuarial basis of the fund. How can the treasurer manage a fund if liabilities can pop up from a century ago?
Does it destroy the fund, or does it just hold the system accountable for its own errors, however long it takes to discover them? Leonin's core point is that the original title holder has the right to safely rely on the indefeasibility of their own title. That's the irony here. If the system promises that your title is conclusive, why do you need to check the registry every week to make sure it's still yours? You are literally punishing them for believing the promise the system made.
Because the system also promises that the new buyer's title is indefeasible. That is the fundamental conflict. And the law resolves it by favoring the new buyer for the sake of commerce and offering the fund as a secondary remedy, provided you act within the statutory period.
But the statutory period is being manipulated by this constructive notice rule. The source material explicitly says that applying constructive notice regarding prescription would defeat the assurance fund's laudable purpose. The victim is the only one who loses here. The fraudster gets the money, the IPV gets the land, and the state hides behind a 6-year clock that started ticking before the victim even knew they were bleeding.
I see the equity argument, and it is a potent one, but we must also look at the strict scope of liability. The assurance fund isn't a magical pot of gold for every grievance. Section 101 of PD 1529 sets very clear limitations.
Right, the specific exclusions.
Yes. The fund is not liable for any loss caused by a breach of trust, whether express, implied, or constructive. Nor is it liable for mistakes in the resurvey or subdivision of registered land that result in an expansion of area. These exclusions exist to prevent the fund from covering private negligence or technical errors that aren't pure fraud or system failure. It's just not a catch-all safety net.
I acknowledge those limitations. Breach of trust is a private matter between a trustee and a beneficiary. If I trust my brother with my title and he sells it, well, that's on me. But we are talking about fraud that exploits the registry itself, strangers forging deeds. And as for the pot of gold argument, let's talk about the funding. This isn't just taxpayer money in the general sense, is it?
It is managed by the National Treasurer.
Yes, but where does it come from? Every time a certificate of title is entered, a contribution is paid to the Register of Deeds, specifically 1/4 of 1% of the assessed value of the land. That is a direct premium paid by the users of the system to insure the system.
That is correct. It is a self-sustaining pool.
And the law states that the standing fund is maintained at 500,000 pesos, but, and this is a huge but, if that isn't enough, the National Treasurer is authorized to make up the deficiency from other unappropriated funds.
Even if not appropriated, yes, the government ultimately covers the difference.
Exactly. So the argument that we must ruthlessly restrict claims to protect the fund's solvency is really weak. The state has the capacity, and arguably the legal mandate, to pay the fair market value at the time of loss. The system charges a premium on every single transaction. It should honor the policy when the specific risk it insures against, loss of title due to the system's operation, actually happens. You can't collect the premiums and then bolt the door when it's time to pay the claim.
The funding mechanism is robust. I agree with you there. But money existing in a vault somewhere doesn't mean the procedure should be ignored. The 500,000 peso cap on the standing fund is just an administrative threshold. The liability is indeed backed by the Treasury. However, that backing relies entirely on the assumption that claims are valid, timely, and follow the strict hierarchy of the remedy of last resort. If we allow Justice Lenin's actual knowledge standard, we aren't just opening the door, we are taking the door off the hinges. You would have claims surfacing from the 1970s. The national budget cannot account for open-ended, infinite liability.
And if we stick to your constructive notice standard, we are nailing the door shut while the house is on fire. The fair market value promise becomes completely hollow if 99% of victims are time-barred before they even realize they've been robbed. The state is essentially profiting from its own inefficiency in detecting fraud.
We are approaching the end of our time, so let's try to synthesize where we've landed. From my perspective, the assurance fund is a vital component of the Torrens system, but it must be understood within the system's own logic. It safeguards the integrity of the registry by ensuring titles are indefeasible for buyers. To do that, it sacrifices the original owner's claim to the land, but offers monetary compensation if, and only if, the victim adheres to strict procedures and timelines. It protects the system first and individuals second.
And that is a chilling, albeit accurate, summary of your side. My takeaway is that the assurance fund is the final bastion of recompense for those sacrificed by the system's operation. It is the only thing offering a semblance of justice to someone who did absolutely nothing wrong but lost everything. Relying on legal fictions like constructive notice to time bar these victims is an injustice that our lawmakers could not have intended. If the system works to strip ownership from an innocent person to protect a buyer, the path to compensation should be paved with equity, not insurmountable obstacles.
It brings us back to that fundamental tragedy of the torrent system we discussed at the top. To provide certainty for a buyer, the system effectively allows for the stripping of ownership from the original holder. It is a harsh calculus, but one the law currently deems necessary for a functioning property market.
It's a zero-sum game played with people's actual homes. The assurance fund is the only mechanism designed to balance that scale. Whether it actually works depends entirely on whether the courts choose to interpret the rules with strict rigor, as you suggest, or with an eye toward the practical reality of fraud, as I hope they will. It's definitely an area where jurisprudence will keep evolving.
A tension that likely won't be resolved anytime soon, but certainly one that every property owner should be aware of. The law rewards the vigilant, not the sleeping.
I hear that, but I just leave us with the thought that vigilance shouldn't require paranoia. Still, your point is well taken.
Thank you for joining us for this intellectual exchange. There is clearly much more to explore in how these property laws are applied in practice.
Keep an eye on those land registries, everyone.
Discuss the concept of compensation from the assurance fund as a remedy made available to persons who, without negligence on their part, suffer damages from the operation of the Torrens system of registration.
The assurance fund is part of our property registration system covered by Presidential Decree number 1529. Its purpose is to protect individuals who rely on a property certificate of title as evidence of ownership. A claim from the fund must meet the strict requirements of Presidential Decree number 1529. The assurance fund is a long-standing feature of our property registration system, which is intended to relieve innocent persons from the harshness of the doctrine that a certificate of title is conclusive evidence of an indefeasible title to land. The compensation envisioned in the assurance fund is the fair market value of the land at the time of loss. The amount to be recovered is not limited to 500,000, which is maintained as standing fund. If the fund is not sufficient, the National Treasurer is authorized to make up for the deficiency from other funds available to the Treasury, even if not appropriated.
Explain the two main aspects of the remedy of an action for compensation against the assurance fund.
In the context of Article 95 of PD 1529, there are two aspects of the remedy of action against the assurance fund. First, it is filed by the person deprived of his land by reason of the operation of the Torrens system, provided there is no negligence on his part and he is barred from recovering the land. And second, it is filed against the persons responsible for the fraud and the Register of Deeds and the National Treasurer,
who are not entitled to recover compensation from the assurance fund.
Section 96 in relation to Section 97 of PD 1529 requires that the person causing the fraud should be impleaded in the claim for damages. Despite substantial compliance with the requirement to implead the person who caused the fraud, this does not cure the non-conformity of respondents Anglo Senior and Anglo Agricultural Corporation's claim with the requirements set in Section 95 of PD 1529. Claims against the assurance fund will not be allowed when the claimant is negligent.
Why is a claim against the assurance fund described as a remedy of last resort, and what does this imply regarding the liability of the assurance fund to the claimant?
A claim against the assurance fund is a remedy of last resort, so execution is directed first against the person responsible for the fraud. If insolvent, then against the National Treasury. Thereafter, the government shall be subrogated to the rights of the plaintiff to go against other parties or securities. The assurance fund is only liable in the last resort, as suggested under Section 97 of Presidential Decree number 1529. The person causing the fraud or the error should be liable first. However, if the judgment cannot be executed, the assurance fund is the insurance to the innocent purchaser for value who relied on the validity of the real property's certificate of title in showing that the person causing the fraud passed away and did not leave property. It meant that the state cannot execute a judgment granting the innocent purchaser's claim from such person. It excuses the claimant from impleading the person causing the fraud or his estate in the petition, because in this situation the judgment may only be enforced against the assurance fund.
What is the prescriptive period for an action for compensation against the assurance fund, and how is this period to be reckoned, particularly in light of the rule that registration constitutes constructive notice to the whole world?
An important limitation to the action against the assurance fund is the prescriptive period. In Spouses Stephanopoulos versus Register of Deeds of Legazpi City and the National Treasurer, the Supreme Court discussed the general rule that the right of action accrues only from the moment the right to commence the action comes into existence, and prescription begins to run from that time. However, the Supreme Court stated, in cases involving fraud, the common acceptation is that the period of prescription runs from the discovery of the fraud. Under the old Code of Civil Procedure, an action for relief on the ground of fraud prescribes in 4 years, but the right of action in such case shall not be deemed to have accrued until the discovery of the fraud. Meanwhile, under prevailing case law, when an action for a conveyance is based on fraud, it must be filed within 4 years from discovery of the fraud, and such discovery is deemed to have taken place from the issuance of the original certificate of title. The rule is that the registration of an instrument in the office of the Register of Deeds constitutes constructive notice to the whole world, and therefore the discovery of the fraud is deemed to have taken place at the time of registration. However, in action for compensation against the assurance fund grounded on fraud, registration of the innocent purchaser for values title should only be considered as a condition sine qua non to file such an action, and not as a form of constructive notice for the purpose of reckoning prescription. This is because the concept of registration as a form of constructive notice is essentially premised on the policy of protecting the innocent purchaser purchaser for value's title, which consideration does not, however, obtain in assurance fund cases. As earlier intimated, an action against the assurance fund operates as a form of relief in favor of the original property owner who has been deprived of his land by virtue of the operation of the Torrens registration system. It does not in any way affect the rights of innocent purchasers for value who had apparently obtained the property from a usurper but nonetheless stands secure because of the indivisibility of the Torrens certificate of title. The underlying rationale for the constructive notice rule, given that it is meant to protect the interests of the innocent purchaser for value and not the original title holder or claimant, is therefore absent in assurance fund cases. Accordingly, it should not be applied, especially since its application with respect to reckoning prescription would actually defeat the assurance fund's laudable purpose. The assurance fund was meant as a form of state insurance that allows recompense to an original title holder who, without any negligence on his part whatsoever, had been apparently deprived of his land initially by a usurper. The ordinary remedies against the usurper would have allowed the original title holder to recover his property. However, if the usurper is able to transfer the same to an innocent purchaser for value and he is unable to compensate the original title holder for the loss, then the latter is now left without proper recourse. As exemplified by this case, the original title holders are, more often than not, innocently unaware of the unscrupulous machinations of usurpers, and later on the registration of an innocent purchaser for value's title. If the constructive notice rule on registration were to apply in cases involving claims against the assurance fund, then the original title holders who remain in possession of their own duplicate certificate of title as petitioners in this case are in danger of losing their final bastion of recompense on the ground of prescription, despite the lack of any negligence or fault on their part. Truly, our lawmakers would not have intended such an unfair situation. As repeatedly stated, the intent of the assurance fund is to indemnify the innocent original title holder for his property loss, which loss is attributable to not only the acts of a usurper, but ultimately the operation of the Torrens system of registration, which by reason of public policy tilts the scale in favor of the innocent purchaser for value. Justice Leonen concurred with the main opinion written by Justice Perlas Bernabe, in particular relative to loss, damage, or deprivation becoming compensable the moment the property has been registered in the name of an innocent purchaser for value. Justice Leonen further points out that Section 101 of Presidential Decree number 1529 expressly excludes from the coverage of the assurance fund claims for loss, damage, or deprivation caused by breach of trust or mistakes in the resurvey or subdivision of registered land. Justice Leonen added that he agrees that the registration of the property in the name of an innocent purchaser for value should not be the reckoning point of the 6-year prescriptive period. Justice and equity, according to him, demand that the right to bring an action against the assurance fund should be construed to commence from the moment that the innocent purchaser for value registers his or her title and upon actual knowledge of the original title holder. For his views, Justice Leonen explained that the actual title holder cannot be deprived of his or her rights twice. First, by the fraudulent registration of the title in the name of the forger, and second, by the operation of the constructive notice rule upon the registration of the title in the name of the innocent purchaser for value. The innocent purchaser for value, according to him, is amply protected by the rule that the Torrens certificate of title is indefeasible and binding upon the whole world. An innocent purchaser for value, by relying on the correctness of the certificate of title, is shielded from any claims that other persons might have over the property. Justice Leonen concluded that the constructive notice rule should not be made to apply to title holders who have been unjustly deprived of their land without their negligence. In this case, petitioners were resident of Spain and left no administrator to oversee their properties. They also had in their possession the title to their property. Although it is true that the act of registration in the name of the innocent purchaser for value is deemed constructive notice to all persons, it is equally true that original title holders have the right to safely rely on the indefeasibility of their title. After all, the purpose of registration under the Torrens system in general is to provide certainty as well as incontestability in titles to land. Justice Kagiwa partly agreed with the main opinion. He stated that he agrees with the ponencia insofar as it grants the petition. However, he submitted that in view of the particular circumstances attendant to the case, the 6-year prescriptive period should be reckoned from the day the spouses Stylianopoulos received notice of the partial entry of the regional trial court's decision in the second action which characterized Amorao and Company et al. As innocent purchasers for value. Since the spouses Stylianopoulos were the ones who filed the second action against Anduiza, Amorao and Company et al. And the assurance fund, then their 6-year prescriptive period to claim against the latter did not even begin to run. Justice Kagiwa added that since the spouses Stylianopoulos lost their land by operation of the Torrens system only upon notice of the issuance of the certificate of finality, as it was only at this point when Amorao and Company et al. Could be regarded as innocent purchasers for value, their claim against the assurance fund can only be deemed to have accrued at such time. That said, however, Justice Kagiwa further explained that the finding of the status of innocent purchaser for value does not prevent the court from reckoning the 6-year period to file an action against the assurance fund, not from the issuance of Amorao's title, but rather from the day the spouses Stylianopoulos received notice of the partial entry of judgment of the regional trial court's decision characterizing Amorao and Company et al. As innocent purchasers for value. To stress, Amorao and Company et al. Status as innocent purchaser for value had been vested not by virtue of the circumstances attending the issuance of their respective titles, but solely by the regional trial court's partial judgment, albeit erroneous, declaring them as such. Stated differently, the spouses Stylianopoulos lost their land by operation of the Torrens system only upon notice of the issuance of the certificate of finality, as it was only at this point when Amorao and Company et al. Could be regarded as innocent purchaser for value. Again, not only on the basis of the circumstances attending the issuance of their respective transfer certificates of title, but only because of the finality of the findings of the regional trial court, considering that such notice came after the filing of the second action, not only against Anduiza, Amorao and Company et al., but also against the assurance fund. Then the spouses Stylianopoulos' 6-year prescriptive period to claim against the assurance fund did not even begin to run.
What losses are not recoverable from the assurance fund?
Section 101 of PD 1529 addresses the situation where the losses incurred are not recoverable against the assurance fund. It declares that the assurance fund shall not be liable for any loss, damage, or deprivation caused or occasioned by a breach of trust, whether express or implied or constructive, or by any mistake in the resurvey or subdivision of registered land, resulting in the expansion of the area in the certificate of title.
What accounts for the funding of the assurance fund, and how is the fund being managed and disposed of?
As far as the funding of the assurance fund is concerned, it is interesting to recall that upon entry of a certificate of title in the name of the owner or of a transfer certificate of title, 1/4% based on the assessed value of the land shall be paid to the Register of Deeds as a contribution to the assurance fund. In case there is no assessment yet, a sworn declaration of two disinterested persons on the value of the land, subject to court approval, is required. The contributions to the assurance fund shall be in the custody of the National Treasurer and shall be invested until the principal plus the interest aggregates to 500,000 pesos. The excess shall be paid to the assurance fund and be included in the annual report of the Treasurer to the Secretary of Budget.